you and your wife or you and your husband are choosing to live separately without a divorce, can a court actually force both of you to stay together? This might come as a surprise, but the answer is yes, a court can do so if your spouse goes to court alleging that you've been living separately without any reason and demanding that you should be asked to live with them. This is called restitution of conjugal rights, but the validity of this provision is under challenge right now. In this KYC episode, I will tell you what this provision means, what the courts have said on it, and how the government is defending this law before the Supreme Court. Now, as always, let me begin with the basics. What do conjugal rights mean? Conjugal rights simply are rights which are created by marriage between two people. So this includes rights under civil laws like property rights, succession, and rights under criminal law like maintenance and alimony to a spouse. Restitution of conjugal rights, as the name suggests, recognizes one such conjugal right, that is the right to live together or cohabitation, and the right to consortium or companionship with your partner. Now, Section 9 of the Hindu Marriage Act and Section 22 of the Special Marriage Act allow this. How can such a case be filed? Basically, if anybody refuses to live with their spouse, the spouse can approach the family court demanding that he or she should be directed to live with them. And under the Code of Civil Procedure, if such a direction is disobeyed, it can actually attract coercive measures like attachment of property. So that person's property can be forfeited. However, the decision can be appealed before a high court or the Supreme Court. Now, this happens a lot when, say, a husband or a wife files for divorce and the other person does not want to give them a divorce, then they file for restitution of conjugal rights instead. The constitutional validity of these provisions were basically recently challenged in 2009 by the students of Gujarat National Law University, which is GNLU, and this petition is being heard by the Supreme Court. Now, these students have basically alleged that this law violates the fundamental right to privacy and that the provision is, and I quote, deeply discriminatory towards women. And experts have also argued that even though the law seems gender neutral because it allows both husband and wife to approach the court, the provision does disproportionately affect women. Women are often called back to their husbands' homes under the provision. And given that marital rape is not a crime in India, it leaves women susceptible to such forced cohabitation with their husbands. But this isn't the first time that restitution of conjugal rights and this whole remedy is under challenge before courts. In fact, such challenges go back to over a century ago, and the struggle is older than Indian independence. In the 1880s, the Bombay High Court was dealing with Dadaji Bhikaji and Rukmabai. So these are two cases and two stories that I'll tell you about. This is one couple. They got married when Dadaji was 19 and Rukmabai was just 11 years old. However, they never really lived together. After 11 years of this marriage, when Rukmabai was 22 years old, Dadaji now wanted her to live with him and asked the Bombay High Court to direct her to do that. However, Justice Robert Pinney of the Bombay High Court refused to allow the husband's demand. He did so on technical grounds, saying that the couple had anyway never lived together, so there can be no restitution of conjugal rights because they didn't exist in the first place. But he also noted that the remedy of restitution of conjugal rights had no foundation in Hindu law and had been transplanted from England to India. He even said that it would be a barbarous, a cruel, a revolting thing to do to compel a young lady under those circumstances to go to a man whom she dislikes. Now, of course, Justice Pinney's judgment naturally generated a storm of controversy in British India, but it was swiftly reversed by a division bench of the Bombay High Court. The case ultimately ended in a settlement between the parties. Dadaji agreed not to pursue the case against Rukmabai or go after her property, which was a possibility, for an amount of Rs 2,000 and went on to get remarried. For Rukmabai, the support that the case garnered led to her going to London to study medicine and become India's first woman medical practitioner. Now, let me take you to another story. The next legal fight over this provision came a century after this case. Back in 1975, 16-year-old Sarita, who was then a high school student, married Venkata Subbaiah. After living together for a little more than 6 months, they started living separately. Sarita went on to become a popular South Indian actress back then, and after over 5 years, her husband decided that he wanted to live with her again. He moved court under Section 9 of the Hindu Marriage Act that I've told you about already. When the lower court allowed the husband's application, Sarita approached the Andhra Pradesh High Court and made a claim that was made for the first time in the history of the provision. She argued that the section was unconstitutional because it violated her fundamental rights to equality, personal liberty, dignity, and privacy. A single judge of the High Court struck down the provision as unconstitutional, said that such an order transfers the choice to have or not have marital intercourse from the individual to the state. The court also ruled that this remedy, and I quote, is a savage and barbarous remedy violating the right to privacy and human dignity guaranteed by Article 21 of the Constitution, unquote. But the same year, a single judge bench of the Delhi High Court upheld the provision. So, of course, there were differences of opinion between different high courts at that time. The Supreme Court settled the debate and upheld Section 9 of the Hindu Marriage Act in Saroj Rani versus Sudarshan Kumar Chadha. It said that the provision, and I quote, serves a social purpose as an aid to the prevention of breakup of marriage, unquote. And this is the line of reasoning that the centre has also now taken on this new 2019 petition. On Monday, the central government responded to this petition and defended the law, saying that the provisions are aimed at protecting the institution of marriage and family. That's all I have for you for now. This is Apoorva Mandhani for ThePrint. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram, and Facebook.